I have to hold it?
Nope.
It is 9 a.m. For a regularly scheduled meeting of the LPA, November 11th. 12th, okay. And we're going to do roll call first. Starting down there, Don.
Don Sutter.
Jim Dunlap.
Doug Ekman.
Jane Plummer.
Jim Bond.
John McLean.
Madam Vice Chair, Chair Anita Saracita has asked for an excused absence.
So would someone like to make a motion?
So moved.
Second.
Okay, it's moved by Jim Dunlap and seconded by, who seconded?
Don.
Jim Bowen. All those in favor?
Aye.
Any opposed? All passes unanimously. Okay, and so we'll start with the invocation, if you all rise. Oh, we should start with the Pledge of Allegiance first. Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
and stand for the invocation. Lord, thank you for being here to watch over us and guide us to make clear, sound decisions for our town. And if you have any, if it is your will, if you could bring some warm weather back, we would appreciate it. Thank you. Yes. Okay, the final approval of the minutes.
So moved.
Support.
Any changes or revisions? Okay, do we do roll call, or do we just say all those in favor? All those in favor, say aye.
Aye.
Unanimously approved. And then, let's see, approval of the minutes of October 14th.
So moved.
Second.
All those in favor?
Aye.
Aye.
Unanimously approved. And is there any public comment? If you're going to speak on a case, it would be better if you could speak on the case so it goes into the record. If you just have a general comment, you're welcome to speak now. Okay, no public comment, so we will close public comment. The next 4 items on the agenda are public hearing for review of various land use requests. For the benefit of the public, please be aware that these items are quasi-judicial in nature. Our attorney will further explain.
Thank you, Madam Vice Chair. Actually, the very last item is going to be legislative.
Okay.
So the formalities that I'll be describing will not be associated with that particular item. However, today, you do have 2 variance requests as well as a special exception. Yes. Special exception. I was thinking conditional use because sometimes they're used simultaneously. Anyway, let me move on here. These are all quasi-judicial in nature, and this requires that today's hearing comply with some procedural requirements that have been established in Florida law and are also in our land development code. So our hearings on these 3 items will be less formal than a proceeding before a circuit court, but they are going to be more formal than the remainder of our meeting, including the discussion on the last proposed ordinance. We will be following basic standards of due process that requires requiring certain notices, the application of the correct standards, and that your decisions are made on competent substantial evidence presented to you in written documents or through oral testimony. Your responsibility today and your duty is to evaluate this testimony and information for each of these 3 items and draw a conclusion regarding whether or not the criteria in the Land Development Code or in state law, as may be applicable, has been satisfied. So pure speculation or opinion that is not based on competent facts cannot legally be considered by you in evaluating an agenda item. Testimony by professionals who have been qualified as experts in a particular area has been considered competent evidence by Florida courts, as well as testimony by neighbors and residents who have fact-based information, such as minutes, surveys, engineering reports, or testimony that's based on their personal information. If you intend to speak, please keep this in mind. When you come forward, please state your name clearly for the record, whether or not you have been sworn in. I also wanted to note that a unanimous decision by eligible voting members of the LPA to approve a variance and certain special exceptions shall constitute final agency action, subject to a request by anyone for an additional hearing or review of the matter by the town council if the request for an additional hearing is received by the town clerk within 10 days. Thank you, and for purposes of efficiency, before we begin these public hearings, I'd like to go ahead and dispose of a few housekeeping matters. First of all, I need to ask our town clerk whether or not the agenda items have been properly noticed pursuant to our land development code.
Yes, they have been.
Thank you. Also, if any LPA member has a conflict of interest that would prohibit them from voting on a particular item, one of these three, please disclose that at this time so we can make sure that we have a quorum present for review of the item.
Should we do roll call?
Yes.
Okay, Don?
None.
No, ma'am.
None.
None for me.
None for
Okay,
me.
Great. So at this time, if there is anyone present today that will be providing testimony, if you would please stand, raise your right hand, and be sworn in by our town clerk.
Do you wish to speak? If you're
Are
going to
you
speak
guys
on
going to
anything, you
be,
need
are you here
to.
for a case or? No?
No,
you're
no,
just-
not speak yet, but if you're going to speak during the
just need
hearing,
to
you
be-
just
You just
need
need to
to
be
swear
sworn
in.
in. Do you solemnly swear and affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Okay.
You're not going to speak yet, we'll call you.
Madam Vice Chair, if I could proceed on, your first item today is LPA Resolution 25-19, variance 2025-0243. This is regarding beach access number 43. The first housekeeping item is to find out whether or not there has been any ex parte disclosures that need to be made into the record.
Don?
No ex parte.
No ex
should-
parte.
Should we say who's speaking, or will they know who's speaking?
She should know.
Okay,
yeah.
okay, I just wanted to make sure. Go ahead, Doug.
Oh, no ex parte.
No ex parte.
None.
No ex parte, thank you.
Okay, and so the next question is who will be testifying and providing information regarding this item? We see Jason Smalley and,
Hi, good morning. I'm Jordan Barble with Johnson Engineering. I'm here on
Okay.
behalf of the Lee County.
okay, so hold on. So Jason Smalley has been qualified as an expert before the LPA based on his experience in the field of land use and specifically in the town of Fort Myers Beach. If you could state your name again for the record and your qualifications and your area of expertise, and then, Madam Vice Chair, it would be a vote to accept him as an expert.
Okay, sure. Again, I'm Jordan Barble with Johnson Engineering. I'm a licensed engineer in Florida, and yeah, I'm here representing as a design consultant for Lee County.
Okay, so,
I move to accept as an expert.
I'll second.
okay, all those in favor? Aye.
Aye.
That unanimous vote.
Have
Thank you,
you-
you are now an expert.
You are now an expert before the local planning agency for the town of Fort Myers Beach. Have you received a copy of the agenda materials? Have those
Yes,
been
I have.
provided to you?
Jordan, can you spell your last name for the record, please?
Sure. V as in Victor, A-R, B as in Bravo, L-E.
Thank you.
Yes.
So, Madam Vice Chair, at this point, I believe it would be appropriate to have staff do a brief introduction and then allow the applicant to present their case.
Okay, so if you want to sit down while he presents, then you can get back up. Thank you. Go ahead,
We
John.
probably should go ahead and read the title,
Oh.
too.
Yes, that's a good idea.
This is a request, again, it was for the variance. This is a resolution of the Fort Myers Beach Local Planning Agency approving with conditions denying variance 2025-0243, requesting a variance of 20 inches or 1.7 foot from LDC Section 34-652D to allow a 60-inch wide or 5-foot wide on-grade pathway where a maximum 40-inch wide or 3.3 5-foot wide on-grade pathway is permitted through a dune in the environmentally critical zoning district for the public access easement, beach access number 43, recorded for the real property located at 102 Estero Boulevard, and providing for other clarifications as necessary, providing for conflicts of law, scrivener's error, severability, and providing for an effective date.
Jason?
Good morning. My name is Jason Smalley. I'm with the Planning and Zoning Department. Good morning, members, staff. So before you today are going to be three separate cases generally dealing with the beach area and reconstruction of minor footpaths and elevated walkways. Excuse me. Sorry. Before you today on the first one is going to be a request related to 102 Estero. That is for beach access number 43. The request before you today is a variance to allow for the reconstruction and widening of a footpath. So this is an at-grade footpath with ground cover, with usually a shell ground cover. And this allows for access to the beach without actual physical construction of an elevated walkway. Previous to the storm, we have confirmed that there was an elevated walkway that was there. It was damaged. The county has determined that they are going to be rebuilding an on-grade path rather than attempting to rebuild an elevated walkway. The ask today is the code limits the width of those walkways to 40 inches, and they are requesting to widen it to a 5-foot on-grade path. So it will be 60 inches. Those are the major differences here before you. The applicant's representative is here if you'd like any more detail about their process, but I'm here to answer any questions you may have for staff.
I've got a question.
Okay. Doug?
So just to make sure I understand, when you say an on-grade path, you're talking about those mats, like just lying a mat over the dune?
Well, the Moby mat may be a portion of this, but this would allow them to construct a footpath if necessary. I'll defer to the county as far as whether they're going to be using Moby mat or if they will be using alternative ground cover to create an actual walking path. The allowance would allow for either option, though. But again, I'll let the county clarify.
I'd like to, when we get to it, understand exactly what we're talking about when we say a path.
Understandable.
Jason, we received a follow-up from the Pink Shell condo people.
Yes.
And the additional width, because the easement is split between two ownerships, are they each contributing, or is it all on one side, the additional width?
Well, they're proposing a 5-foot wide Moby mat here, and the easement is 6 foot. So out of necessity, a portion of it is going to be on the Pink Shell side of the easement. So the agreement with Pink Shell, from what I understand, they're supportive of this, that they just wanted to make sure to understand that portion of this easement is their property and under their control through the easement. So from what I understand from the email, they don't dispute that this needs to go in and that it's going to stretch across both of them. I believe their problem was that the legal description didn't fully encompass their portion of the easement. During the development order phase, we will be getting surveys and we will have the full legal description, and that'll be expressed in the development order. So it's registered in the deed that it is still part of their property.
Okay. So, anyone else have a question? All right, so we'll call you back if we have any other questions.
Of course.
Is it George? I'm sorry, I didn't get, Jordan?
Jordan.
Okay,
Yes.
Jordan,
This
if
is
you'd
Jordan.
like to say your name for the record and go ahead and give your presentation.
Again, sure. I'm Jordan Varble with Johnson Engineering, and I believe Jason said it. The county would like to propose to install a beach access path through an existing easement to allow the public to access the beach.
Have you gone over the conditions and agreed to the conditions that have been provided?
Yes, the one condition I would like to ask about would be it allow construction during sea turtle nesting season? Actually, that may not be on this one, it may have been on 41. That was on 41.
Yeah.
I apologize.
Jason, would you like to respond to that?
So, much like the Bowditch issue, staff, from what I understand, does not have an issue with them working under the auspices of the permit during turtle season. As always, if there's any monitoring that is required and necessitated, that's going to be the responsibility of the applicant, done in conjunction with Chad and the turtle program. So if they wish to work during that point, then they'll do it under the normal process allowed for in their state license and in conjunction with the town's environmental program.
Jordan, do you have any idea what the time frame is for construction,
As far as the
beginning to end?
beginning to end, it should take 90 days.
And how quickly can they start?
So, yeah, logistically, once the permits are in hand, let's say 3 months for procurement, 3 months for construction, so.
All right, thank you.
So can you go through the details of this pathway that you're talking about? How is
Sure.
it constructed? What does it consist of?
Sure, so there is a little dune at that part of the beach, and so the county would like to install a Moby mat, one of those blue mats with posted rope on both sides to get up and over that dune. And then between the sidewalk and the dune, it would be a shell path or any sort of improvement as needed to get, wheelchair access to that Moby mat.
So a shell path in the flat areas, a Moby map over the
Over the
rise of the dune, and then
Yes, sir.
on the seaward side of the dune, a shell path too, or is that it?
No, once you're on the seaward side of the dune, it's just the
Sand.
beach.
Okay.
So the 110 feet starts, there's going to be a standard path from Estero Boulevard to approximately where the fence stops on the property to the left, and then the 110 feet will go from there?
Correct, yep, yes.
Okay.
Probably the CCL,
Yeah.
Yeah.
Turtle seal.
CCL.
Jason,
else?
can I ask you a question for a second?
Of course.
So for all practical purposes, they're putting back what was there before? Or are there changes
Yes.
that you should
Yeah,
highlight?
I believe, and correct me if I'm wrong, it was permitted as an elevated path previously. That's what the staff report seems to indicate. That was destroyed, and then they're not continuing with an elevated path here anymore. It'll just be the Moby mat and then the crushed shell at the beginning of the pathway.
And just for clarity, we talk about a lot of expediencies and efficiencies. They're in front of us due to what restriction they have to get from us? And they're just putting back, in fact, less invasive?
So what they're asking for here is an increase in the width of the
Oh,
path.
that's right.
Under normal circumstances, it would be 40 inches. They're requesting, I'm assuming because of the Moby mat's dimensions, to increase it to 5 feet.
Is that the new standard, Jordan, with those come in?
So the path that was there before was 5 feet, so
Oh, it was.
we're holding to what was there.
Okay.
You're correct, it's less intense than what was there before.
Okay, thanks.
I would agree that a path narrower than 5 feet is not too practical.
Right, especially with handicap
Just
access.
putting that, gotcha.
Yes.
Any other questions? Yes, John?
Yeah, I just have the one question, and it's from the email that we got, that they're asking that the county ensures that the reconstructed pathway is centered on the property line as originally platted, as opposed to strictly on one of the properties, or more advantageous to one of the properties.
Yes, sir, it will be centered on the.
Okay, thank you.
Any other questions? All right, is there anyone in the public that would like to speak on this case? We'll close the public hearing, close public speaking and bring it back to the table. Would anybody like to make a motion?
I'll make a motion to approve variance 202-50243 as recommended by staff and with conditions therein.
May I ask a question? On page 15 of your agenda materials, there are certain findings that need to
Yeah.
be made.
Yes, findings and
I'm
conditions.
in
So
condition
you're-
with the findings, yes.
That the findings have been satisfied.
They have, thank you.
Thank
And the
you.
4 conditions will be applied.
Yeah, that part I did, but
There's
Second?
3 conditions.
Second.
There's 4 on mine.
Oh, Maybe I'm looking at the wrong one.
Okay. Okay, so we'll do a roll call. Who did the second? I'm sorry, Jim? Okay. Jim did.
Jim, didn't it?
This Jim and that Jim. Okay. So roll call Doug? Don, I'm sorry. Oh, wait, you do it to the person who made the motion. I'm sorry, I'm not in order here. Jim Dunlap?
Aye.
Jim Bowen?
Aye.
Don Sutter?
Aye.
Doug?
Aye.
Aye.
John McLean? And Jane Plummer, aye. Unanimous vote. So this will make it pass and not have to go through the town if there is no conflict presented to the town within the next 10 days. Is that correct?
Correct. Objection filed with the town clerk.
Okay. So we will move to the next hearing.
The next item on the LPA agenda is LPA Resolution 25-21, VAR 202506261, and this is for beach access number 41. A resolution of the Town of Fort Myers Beach, local planning agency approving with conditions, denying variance 20-25-0261, requesting a variance from LDC Section 34-652F2C to allow an 8-foot wide dune walkover where a maximum 6-foot wide dune walkover is permitted for uses other than single-family residential in the environmentally critical zoning district. For the public access easement, beach access number 41, recorded for the real property located at 252 Estero Boulevard, and providing for other clarifications as necessary, providing for conflicts of law, scrivener's errors, severability, and providing for an effective date.
Okay, we covered all of the properties with the disclosure, or do we do it individually here?
Technically, it should
conflicts.
be individually.
Okay, so, but the conflicts were covered, correct?
Yes, you can
Okay.
go ahead and just say
So-
generically.
Any disclosures needed for ex parte? Don?
None.
None.
Jim? Doug?
No, ma'am.
Jim?
None.
John? Jane? None. Okay, no disclosures. I do need to make a correction before we move forward. There were only 3 conditions on the last hearing, so we need to correct the motion because we said 4 and it is only 3.
Okay, is there a motion to
So Jim,
correct
would you
that?
correct your motion?
Corrected accordingly?
And Jim?
Second the amendment.
And do we need to vote again?
Yes, on this correction, yes.
Okay, very good. Jim, please?
Aye.
Jim?
Aye.
Don?
Aye.
Doug?
Aye.
John?
Aye.
Jane? Aye. I want unanimous. I'm sorry about that error. Okay, there are 4 on this one, just so we're clear. Okay. Jason, would you please give your?
Of course. Good morning again. My name is Jason Smalley, Planning and Zoning Department.
I don't. did
I'm
we-
sorry, I
don't
didn't do
think
ex
we
parte.
did ex parte.
No worries.
Yeah. Oh, you did.
We did? Okay, all
Okay.
right, she's got it.
Okay,
I wasn't sure. And then the
we did.
Is
identification
there
of the participants,
public
we have the
comment?
same individuals. They are both, have been qualified as experts. And we are ready to proceed.
So before you today are a variance and a special exception that are intertwined with beach access number 41. This is associated with 252 Estero Boulevard. This is another building within the Pink Shell PUD. This is for the, I believe it's called the Villas, the Beach Villas building. Again, the request before you is a variance to start out with. We'll be doing a special exception on this same property here after this one. So the request before you today is to vary the width of a proposed dune walkover. Again, I'll mention that this is separate than the dune path, which we just talked about previously. This is for an elevated dune walkover. Walkovers within our code are limited to 6 feet in width. The applicant is proposing to do an 8-foot wide dune walkover elevated, I believe, 3 feet. So the initial request before you is to vary the width and allow for a wider dune walkover. I will defer to the county and their representative for any specifics on the plans and on the engineering of it, but staff is here for any questions you may have about our process.
Any questions for Jason at this time? Okay, go ahead, Jordan.
Great, sure. Good morning. Again, I'm Jordan Varvel with Johnson Engineering. So the county's proposing to reinstall a boardwalk that was there before the hurricane, the same footprint that was there. So it's really a like-for-like, minor deviation in elevation. But other than that, it's a similar structure to what was there before the storm.
So the Moby map that's there now looks to be about 4 feet or so. I didn't
Okay.
walk it. So you want to go, are you going to do the Moby mat for 8 feet?
No, the Moby mat will be removed and redeployed elsewhere, I guess. But it will be a boardwalk with pilings and timber frames and a
They're proposing a
Okay.
wood and composite deck boardwalk.
And the whole thing, or just the walkover will be 8 foot wide?
the entire boardwalk will be 8 foot wide.
Doesn't the town say that walkovers or the, are typically to be 6 foot or less?
Yeah, so they're getting variance.
That's why they're asking. a variance.
That is correct, yes.
Okay.
And so they're requesting an additional 2 feet in width.
Okay, all right. Any other questions?
Why, is the 8 feet just to put it back like it was?
Yes, sir. Yes.
Is there, Jason, is the reason for the 6-foot limit in the town ordinance, is there any particular reason for that? Or is it just a judgment?
I can only guess, I'm sure there's an arbitrary nature to it, but 6 foot would accommodate a single wheelchair and then somebody helping them behind. I would have to assume that it was intended originally to minimize any of the impact to the EC.
I have to say, I'm hesitant to approve an increase in width just because that's the way it used to be, frankly.
Jason, has there been any concern by the property owners? Has there been any comment by them at all?
We haven't received any concern from any adjacent neighbors about the width in particular, no.
My question would be, do you think if we approve an 8 foot here, that we will be seeing multiple 8 foot requests to do over dunes? Because we are putting in a lot of dunes.
Correct.
And if there's going to be a walkover that's going to be built, are we going to see all 8 foot walkovers?
So what I can tell you is that this isn't precedential, as I'm sure you're aware, but any requests to have additional larger boardwalks out there would need to come before you or town council at that time. I couldn't say whether anybody else would want to replicate that at other beach accesses, but at the very least, you would have a chance to read through that request before it were given approval.
And I would like to add that the first finding that you make in approval of any variances is that there are extraordinary circumstances inherent to the property that is before you that would basically make the request reasonable and de minimis under the circumstances. So it is a case-by-case basis.
Correct.
Although they may ask.
Correct.
So what could you, Jordan, could you tell us what the extraordinary or condition is that is making this approval meet the findings and conditions that are required? Findings and conclusions that are
Yeah, I was
required?
just reading through that. I believe it says here that this request will not introduce exceptional or extraordinary conditions, that it's a de minimis increase in width from what's there, but
I also think that there was testimony that this was there before
This is a
in
build
this
back,
size.
right.
The build
Yes.
back.
So it's a like for
Like for
like.
yeah.
There was a actual wooden thing that went over before?
yes,
Yeah.
ma'am.
Yeah,
Okay.
thank you.
Is that actually, if you look at the picture.
The picture's got it on there.
Okay.
Yeah, I'd like to point out that the easement underneath the condo building on the drawing appears to be 8 feet, so it would be consistent with that portion of the walkway.
Okay, thank you.
And I would also say, even regardless of what was there before, this, my opinion, these type of walkovers are less damaging than the flat ones where people can walk anywhere they want. They get to 8 feet anyway, when two people are walking side by side and pull in their strollers and do what they do. I think this causes less damage, more permanency.
Good. Okay, any other questions for either Jason or Jordan? Thank you. Anybody from the public wish to speak at this time? We'll open the public hearing, or public comment? No public comment? We'll close public comment and come back to the table. Any discussion here?
I'm going to vote against it, but I agree with what Jim said about the raised walkways are less damaging, and I like that there's railings on it, so it contains people walking on it are restricted to the actual raised walkway. I like that, but I don't see a reason to change our ordinance
From
just
8 to
because it
6.
used to be 8.
Okay. Anybody else want to make a comment?
I would just restate that it appears that the walkway through the building is 8 feet, and if it was there for a pinch point, it would be inconsistent and actually inconvenient.
Correct.
Okay. Anybody want to make a motion?
I'll make a motion. I'd make a motion to pass resolution or variance 2025-0261 for beach access 41, given that it meets the condition, with the conditions, 4 conditions that were applied, and meeting that it meets all of the requirements.
And the
Second.
requirements are on page 89, if anyone's asking. This is the exceptional or extraordinary circumstances. The rest of them are all there.
Okay, we have a motion on the table brought by John McLean and seconded by Don Suddeth. All those in, we have to roll call, I'm sorry. Motion by John, please.
Approved. Aye.
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 Doug? Okay. Jim?
Aye.
Don?
Don, yeah, I'm Don.
Doug?
Nay.
Yes.
Aye.
And aye. So that's 6, there's only 6 of us here, 5-1.
I'm sorry, who was the second on that one?
The second was Don
Don?
Suddeth,
Thank you very much.
and the vote was 5-1.
So that one is not unanimous, so therefore that one will require a second hearing before the town council.
Okay. Moving to,
Your next item is LPA Resolution 25-20, SEZ 2025-0241 for beach access number 41. This is a resolution of the local planning agency of the town of Fort Myers Beach, Florida, approving with conditions, denying special exception SEZ 2025-0241 to allow like-for-like replacement of an 8 feet wide and 110 feet long elevated dune walkover in environmentally critical zoning district seaward of the 1978 CCCL coastal construction control line for the public access easement, beach access number 41, recorded for the real property located at 252 Estero Boulevard, providing for scrivener's errors, severability, and an effective date.
okay, does anybody have any disclosures of
Ex parte?
ex parte, brain dead here?
No ex parte, Don.
None.
None.
None?
None.
None.
No ex parte. So, Jason, would you like to move forward?
Of course. Again, for the record, my name is Jason Smalley with the Planning and Zoning Department. Before you today is the concurrent special exception that goes along with the variance that you just heard. The special exception before you today would be for the actual placement of the structure seaward of the 1978 CCCL line. So whereas before you were taking a look at the proposed width, what you have before you today is the allowance of the structure in toto with the 8-foot wide width. If the variance is not approved at town council, you would be approving the replacement of the 6-foot wide allowed elevated boardwalk, but not at 8 feet. So just so we have a little separation and we know what follows what here. So before you is a request for like-for-like replacement. They are proposing ultimately 8 feet wide, 110-foot long boardwalk, again at the Beach Access 41. So again, that is on the Pink Shell PUD property. The staff has looked through the records. We do understand that the elevated boardwalk did exist before and that it was affected largely by the storm and has been taken down. This request here is to replace it. I would note that this resolution does include the sea turtle language. So if there is an inclination to approve this, I would request that you go ahead and remove that. Again, we will be working with the county through the environmental program. They will oversee that and do any monitoring that's necessary. If there's any required monitoring, that cost will be borne by the applicant, the county, rather than the town. The applicant is here for any questions that you may have, and I'm here for any questions you may have about staff's process.
Jason, the special exception standard is on page,
It's 222 and 223, the findings that would be required.
I know, but I'm just asking about the special exception that is written on page 197. So this is not about the width or anything else, it is just about going over the CCL.
Right. I wanted to clarify that in this resolution, it talks about an 8-foot wide, 110-foot long structure. That is assuming that the variance gets approved, which was the point of the variance, to extend it to 8 feet.
And so if it goes to 6 foot, it will be corrected to that.
Yes, if council decides not to approve that variance, they would still, and this went through, then they would be allowed to construct the largest boardwalk that they are capable of under our normal code, which would be 6 feet wide.
Okay. Any other questions for Jason? Okay. go
Yeah, so
ahead.
just so we're clear, this is special exception is for the length of the boardwalk.
No,
No, sir.
this is only to go over the CCL.
Correct.
Oh, over the,
That in and of itself requires this process.
Yeah,
The
which is
initial,
110, which
It's the
takes it
length,
out
right.
over there.
yeah, got it.
Okay. Any other questions for Jason? Jordan?
Sure.
The
So-
the additional length into or beyond the CCL line, is that being motivated by ADA requirements?
The goal here is to get it as close to the water as possible. Sure, it's for wheelchair access primarily, but, all sorts of ADA access. And again, it's going back in the same footprint that it was before.
Yeah.
And the county is receiving FEMA reimbursement funding for this structure, which helps predicate, it really, to help with the funding, it needs to go back as it was, so that the county doesn't put their funding in jeopardy with FEMA.
Okay. So, anybody have questions for Jordan? Is there anyone in the public that would like to speak on this item? Seeing no one, I'll close public comment and come back to the desk. Is there any discussion? Okay, anybody ready to make a motion?
I'll make a motion to approve special exception 202-50241 for Beach Access 41, consistent with replacement of what was there before and with the findings and conditions therein by staff.
Second.
would you also, pardon me, would you also like to make a removal of the language about turtle season or have them work under the normal turtle
Which
season?
means the monitoring will be by the applicant at their expense.
Absolutely.
Okay.
Second. Settle.
Okay.
Can I just add on the record that the findings that are required are in LDC section 34-84 and 34-88? And my understanding is the motion is that the criteria has been satisfied.
That's correct.
I don't have the conditions in front of me. How many conditions were there?
4.
Four conditions, okay. The motion to approve or deny was made by Jim Dunlap and seconded by Don Setta with 4 conditions. We'll do a roll call. Jim?
Aye.
Doug? Or Don?
Aye.
Can I do that? Doug?
Aye.
Jim?
Aye.
John?
Aye.
Jane? Aye. Okay, so that passes unanimously. Okay, thank
You're-
you.
Your next item is legislative in nature, so we will not have as much formality as we've had for the last 3. This is proposed ordinance 25-27 for certified recovery residences. The title's a little long, so bear with me. An ordinance of the Town Council of the Town of Fort Myers Beach, Florida, establishing procedures for the review and approval of applications for reasonable accommodations needed to operate certified recovery residences from existing land use regulations in new section 34-204 in Division 4, Applications and Procedures of Article 2, Zoning District Standards and Nonconformities of Chapter 34, as mandated by Section 397.48715A Florida statutes, and amending Section 34-32 required hearings of Division 5, public hearings and review of Article 2 zoning procedures of Chapter 34, zoning districts, design standards, and nonconformities to require only one public hearing before the local planning agency, LPA, for approval of applications for reasonable accommodations to operate a certified recovery residence as provided in Section 34-204 if the decision by eligible members of the LPA is unanimous and the town clerk does not receive a request for an additional public hearing before the town council from anyone, including town staff, within 10 days after the LPA decision, providing for codification, severability, scrivener's errors, conflicts of law, and an effective date. So Jason is not here, I can take this one. So the approvals for certified recovery residences has been preempted from local governments to the state. And what is now required is for the local governments, including counties, to come up with a procedure in the event a request is needed to provide a reasonable accommodation. The reasonable accommodations would be somewhat similar to a variance. So if they do want to locate one of these type of facilities and they need a variance, the process by statute is an expedited one to move them very quickly through the process. That's the first part of this proposed ordinance. The second part is because of the need to expedite it, we would be requesting that there only be one public hearing before the LPA. Again, similar to the process that we have in place now for variances, which these reasonable accommodation requests, again, would be very similar to a variance. There is a deadline to have a procedure in place by January 1st. So this has come to you in November. We have it scheduled for first reading before the town council on December the 1st and second reading on December 15th. So we'll meet that statutory deadline of having a process in place. My conversations with Jason Green has been that we really don't have any of these type of facilities on, in the town. However, because of Florida statutes, we do need to have a procedure in place, should it be needed. And Jason, I'll defer to you if you want to add anything.
So if we don't have any, we're not talking about temporary structures on properties, we're talking about a facility.
A facility for recovery residences for individuals who are undergoing treatment for certain types of conditions.
Exactly.
Yeah, so, yeah, just so I'm clear, what we're talking about is like a halfway house or something like that. It's like a,
Something like that.
Rehab.
And
Yeah.
an existing law basically doesn't give the local governments a lot of discretion as far as the approvals for those type of facilities. But they are giving you a little bit of discretion as far as the reasonable accommodations that might be needed, like you might need to have a driveway larger than whatever, but there is a process.
relaxed parking requirements or something.
It would still come through the local government, but it has to be expedited. So again, that's why we thought one public hearing before the LPA would be sufficient. And you all have done great with the other variances. I think I've heard feedback from others that it really has expedited approval process and for the benefit of the residents.
So, yeah, just so I understand, so if an entity was proposing a recovery facility and they needed amendments or, variances,
Yeah.
we would expedite the review of those variances.
Correct.
basically.
At the staff level, they pretty much will have to move it to the top of the stack and then give it to you. I believe there's a 30-day period going back and forth, and then it should be resolved within a 60-day period.
And these are
10 days.
when you say certified, it's like some certification by some
Licensed
accredited,
By the state.
by the
Yeah.
state, yeah. Okay, I see.
And there's no conditions or anything else put on these, but they have to meet certain criterias.
The criteria is in the draft ordinance.
Right.
They must comply with requirements in the ADA as well as the Fair Housing Act.
Those are all federal compliances,
Right,
though. They're
right.
boilerplate automatic.
Yeah.
Yeah.
Nancy, is local rule have any power around the zoning of these facilities, or is that preempted by the state as well?
That's been preempted, and unfortunately, it's been preempted for many, many years.
Okay.
In single-family districts, I believe that now there's a preemption that's been expanded into multifamily. But it is a preemption, so there's really not a lot of decision-making or discretion that a local government can exercise on this matter.
Okay.
Jason, do we have any applications for any such kind of, nothing? Okay. I'm just wondering if there's some discussion out there that is bringing this, or is this just state mandated that you have it?
I think it's just state mandated. Working with our other clients, our other local governments, everybody is really running very quickly right now to try to get something in place. And as you'll see, that the ordinance itself is not super intense.
No, it's
You
not.
just want to comply with state law.
Maybe just for the interest in doing the work with the Charter Review Group, John, back to your question on zoning. It's been interesting to watch the evolution of this state mandate occasions coming down since 1983, when they started to propose overruling some local rule with governments. It's been 1,050 unfunded state mandates
Oh, man.
come to local communities during that period of time that have removed independence, line item by line item. I'll add this to the list.
Wow, that's amazing. Any other conversation? Okay, anybody want to make a motion?
So the motion would be that we adopt this ordinance or recommend adoption?
Recommend
Well, we
adoption
recommend the
as
council.
consistent
We
with the
recommend the
comp plan.
council.
Yeah.
I guess I would make a motion that we recommend to council that we adopt the ordinance consistent with the state
Second.
mandate.
There has been a motion by Doug Ekman and a second by Jim Bowen to approve. Now, this can be a group vote, roll call. Okay, Doug,
Aye.
Jim,
Aye.
Don,
Aye.
Jim,
Aye.
Aye.
John, and Jane, aye. So this passes unanimously. Okay. Then we will move to administrative agenda. Do you have anything for us on things that are coming for us next month? Amy?
Jason?
Jason?
So we don't have any very large projects that I'm aware of that have been scheduled. I believe that the December meeting may have one of the larger projects you've heard about out there, but I don't want to get ahead of the agenda makers right now. For the most part, we've got just a normal set of requests that you've seen over and over again, variances and special exceptions through the end of the year.
Okay. LPA item members, items and reports, I can't talk. Anybody?
None for me. Nothing.
No, I'm good.
I would just like to congratulate Don and Mike Miller for the opening of the Whale. We are excited to have 3 new restaurants on the island in one building, and it is an absolutely beautiful property. They've done it's a work of art. So happy for them. LPA attorney items?
No legal items, but I just wanted to get some clarification. If we do have a large project coming that might take up a lot of time, would the LPA be interested in perhaps a separate meeting on that? Or just give us the discretion and we can reach out for scheduling purposes? I don't know, Jason, how many other items? Just one so far? Okay, well, it should be fine then.
Okay.
I'll be quiet.
You can always ask.
Right.
Okay.
You can always condition.
You can always ask for an extra meeting.
Yeah. Community development items? Nothing? Okay, items for next month's agenda, we've already gone over.
Motion to adjourn?
Motion to adjourn, second,
Second.
by Jim and Jim. Thank you. That was a quick meeting.